Welcome back to the ground of voidable marriage. The third ground is no valid consent due to duress, mistake, unsound mind, or otherwise under section 70C of the LRA. Either party to the marriage did not validly consent to it, whether in consequence of duress, mistake, unsoundness of mind, or otherwise. Marriage is a contract, therefore the absence of consent will invalidate the marriage. For duress, we refer to the case of Buckland and Buckland. The principle in this case is marriage out of fear, referring to duress, is a voidable marriage. Petitioner in this case was a policeman employed in Malta. While working there, he went around with a Maltese girl. The girl parent forced him to marry her. She was only 15 years old at the time. He married her out of fear. When he returned to England, he applied for nullity of marriage and the court granted the petition. The next case is Cooper and Crane. In this case, Collins Che laid down the test to be applied in determining the validity of marriage for the absence of consent due to duress. The said judge stated that in order to hold that the ceremony was not binding, I think I should have to infer one of the two things. Either that the petitioner was so perturbed by terror that her mind was unhinged and she did not understand what she was doing, or that though she understood that she was doing, her power of volition was so paralyzed that by her word and acts, she gave merely expression to the will of the respondent and not her own. So in this case, the respondent, who had unknown to the petitioner, obtained a license and arranged the wedding, took her out, and having got her to the church, threatened to blow his brains out unless she went to the church and married him. It was held that the petitioner had not discharged the burden of proving that the marriage was invalidated by fear. This case was followed by sector and sectors. Okay, now we go to Singh and Singh's case. In this case, the petitioner was the 17-year-old daughter of Sikh parents who arranged her marriage. When petitioner met the man, then 20 years old, chosen by her parents for the first time at the registry office, she did not wish to go through with the civil ceremony, but claimed that she did so out of deference to her parents' wishes and to her religion. According to Sikh custom, the parties separated after the registry ceremony and arranged for the religious ceremony, after which the marriage was to be consummated, to be held in a Sikh temple a week later. However, the petitioner refused to attend the religious ceremony and did not have anything further to do with the husband. Petitioner's undefended petition for nullity on the ground of, inter alia, duress induced by parental coercion was dismissed at first instance. In dismissing the appeal, the court held that in order to establish that there had been duress which initiated consent to the marriage, a petitioner would have to show that their will was overborne by genuine fear induced by threats of immediate danger to life, limb, or liberty. On appeal, the court held that even though petitioner had acted out of respect for her parents and her religion, there were no such threats and hence no duress. Now, for the case of mistake, we are referring to Mehta and Mehta's case. The principle in this case is mistake as to the nature of the ceremony amounts to voidable marriage. The petitioner in this case thought that the marriage ceremony was for her conversion to the Hindu religion, but it turned out that the ceremony was a marriage ceremony, and the court held that the marriage was a voidable marriage. The next case is in the marriage of N. Osman and Murali. The wife applied for the nullity of marriage based on the ground that her consent given to the marriage was real consent because it was obtained by fraud. The husband, a foreign national, went through a marriage ceremony with the wife in Australia for the purpose of being allowed to reside there. After the marriage, the husband refuses to cohabit with the wife. The only reason he married her was to enable him to be permitted to reside in Australia, where the wife had a permanent resident status. The court referred to the case of Moss and Moss. The marriage is void because the purported consent was given to something other than marriage, or to the marriage with someone other than the person physically standing at the altar. But if the person wishes to go through a ceremony of marriage with a person whose identity he or she is aware of, then it mattered not that the consent is included by promise of eternal happiness, luxurious living, or even the promise to live together ever after. Okay, note to ponder. Okay, in this case, the marriage was contracted before 1st August 1971, where lack of consent made in marriage before this date was void. However, under Section 13 of the Matrimonial Causes Act 1973, lack of consent made the marriage is voidable. Okay, next thing is unsoundness of mind. The marriage was voidable if it's shown that either party was at the time of the marriage of unsound mind or subject to recurrent fits of insanity or epilepsy. Annulment in such cases was subject to the conditions set forth in the ordinance, which provided that the petitioner must have been at the time of the marriage ignorant of the facts. Proceeding for annulment must have been commenced within a year from the date of the marriage, and marital intercourse with the consent of the petitioner must not have taken place since the discovery by the petitioner of the circumstances. The petition was based on the general state of health of the petitioner or the respondent at the time of the ceremony, and the petitioner might therefore obtain relief even though the party in question understood the nature of the contract he was entering into. The case to be referred to is in the estate of Park. The principle in this case is the correct test to determine unsoundness of mind is whether he or she was capable of understanding the nature of the contract of marriage that he or she had entered. The deceased contracted a second marriage and made a new will which revoked his earlier will. The beneficiaries of the first wife claimed that he was on sound mind when he entered into the second marriage. However, the court held that the marriage was valid as the deceased was able to appreciate the responsibilities normally attaching to the marriage. Okay, next ground for voidable marriage is mentally disordered person under Mental Disorder Ordinance 1952. It is stated under Section 70D of the LRA. At the time of marriage, either party, though capable of giving valid consent, thought capable of giving a valid consent, was whether continuously or intermittently a mentally disordered person within the meaning of the Mental Disorder Ordinance 1952 of such kind or to such an extent as to be unfit for the marriage. Okay, next ground is venereal disease in communicable form. Okay, stated under Section 70E of the LRA. At the time of the marriage, okay, according to this section, the respondent was suffering from venereal disease in a communicable form. For example, he suffers from AIDS, STD, etc. And the next ground is respondent was pregnant by some other man. Referring to Section 70F. At the time of the marriage, the respondent was pregnant by some other person other than the petitioner. Now we come to the last provision under nullity of marriage, i.e. Section 71 of the LRA. This provision applies only to voidable marriage. The first one, for petitions under Section 70A until D, For example, under 70A, no consummation due to incapacity. 70B, no consummation due to willful refusal to consummate. And 70C, no valid consent due to duress, mistake, unsound mind, and otherwise. Or otherwise. And the last one is under section 70D, mentally disordered person under Mental Disorder Ordinance 1952. The petitioner, with knowledge that he can avoid the marriage, led respondent to believe that he would not do so, and it is not unjust to respondent to grant the decree. The second one, for petition under section 70E and F, venereal disease in communicable form, and respondent was pregnant by some other man. Petitioner's knowledge of the fact about the above matters will deprive his or her rights to apply for nullity. Thank you.